Okay, well, here we are again. And here is our dear colleague Edgardo from Guadalajara. And you have already met him this morning, and I'm going to meet him some more, talking about one of my favorite topics on the CISG, and that is remedies. Please do not hesitate to interrupt him at any point in time, ask questions, and seek for additional clarifications or make comments. That's how we plan to proceed. Edgardo, thank you so much.
No, on the contrary, again, thank you so much to Professor Milena, Marco, and Vladimir for having me here. I really feel privileged to be in front of such engaged audience who is ready to stay here until late this afternoon or evening. And yes, again, I will talk about remedies for breach of contract. Remedies is a concept term used by the convention to talk about those, in another way, rights and actions that a party who suffers a breach may start against the breaching party. But the term of art in this case is remedies, obviously, that comes from the common law. And I'm going to focus on the remedies of the buyer in this presentation, but obviously the seller also has remedies in case of breach of obligation of the buyer. And that would be the seller's remedies. But I think it's from an educational point of view, it's more interesting to review those rights that the buyer has against the seller, those remedies. And the most important provision, or the introductory provision about the remedies for breach of contract by the seller that the buyer can activate or trigger, is Article 45. So we may go to that provision in your copy, and you will see that in very simple terms, what this provision, Article 45(1), tells us is that if the seller fails to perform any of his obligations under the contract or the convention, the buyer may exercise the rights provided in Article 46 to 52. I will talk about some of them, the most relevant, and also claim damages under Article 74 and 75. From this introductory provision, we can already conclude some things about how the CISG works. And Professor Schwenzer has already advanced this strict liability, but also unitary approach that the CISG takes with regards to breaches. It's called the unitary approach because the CISG doesn't distinguish between a breach consistent in the delivery of non-conforming goods or the delivery of goods containing title defects or the delivery or the non-delivery at all. The buyer can access all these remedies. He can access all those remedies, except that for some of them, you need fundamental breach. And that was the concept that Professor Garro was talking about. But this is already different to the approach taken by national jurisdictions of both civil law and common law, because in the civil law, in the case of your civil code, that probably works like mine and the Latin American civil codes, you have different remedies depending on whether you, as a buyer, are complaining that the goods have what is called redhibitory vices, that the goods are not fit for the purpose, or the goods are not of the average quality, or the goods are not for the ordinary use. And where civil codes, it gives us access to certain remedies, and especially it sets specific times for complaining about these remedies. But for other type of breaches, for example, the non-delivery of the goods, in our codes, we will need to have a look at the general part of obligations to see what is the limitation period for that, and what are, for example, the prerequisites for claiming a general breach of obligations. For example, that there is delay. This is the case in many civil codes. The CISG, again, doesn't distinguish this, and also doesn't distinguish about impossibility ab initio or subsequent impossibility. All of these are breaches and are dealt with by the system of remedies of the convention that are in the provisions I told you. And these remedies in particular are those who are here. You have a right to specific performance. You have a right to reduction of price as a buyer. You have a right to avoid the contract. And you have a right of damages. You can access more than 2 remedies only if that is compatible with the type of remedy you choose. But in all instances, you may choose damages with other type of remedies, for example, specific performance or avoidance. So if you allow me, I'm going to talk first about the remedy of a specific performance. Okay? So the remedy of a specific performance is in Article 46 in general. And a specific performance is basically when you request the seller to do what he was expected to do. And so it has there are different ways so that the seller can try it again to perform. One way is to deliver the goods again. For example, if he delivered defective goods, he can try to replace those goods and send substitute goods. That's a specific performance, for example. Another way to accomplish a specific performance is to repair the goods that he already delivered but are not conforming. And so this would also be a type of a specific performance. And last but not least, when the seller hasn't delivered at all, specific performance basically consists in asking him to deliver, even if with some delay. Okay? Now, for the type of a specific performance that consists of delivering substitute goods, which means taking back the goods he had already delivered and sending again new goods, for this remedy to be able to access it, you need that the delivery of the first goods amounts to a fundamental breach. And that's the concept you review with Professor Alejandro Garro, right? So for a fundamental breach to occur, it needs to deprive, in this case, the buyer of what he was entitled to expect under the contract, and the seller should have been able to see the effect of this deprivation at the time of the conclusion of the contract. And on this topic, the delivery of substitute goods is generally available to all buyers whenever there is a fundamental breach. But the convention has a provision in Article 28. It's a provision that I haven't seen much invoked in practice, but it seems to be a concession for the common law tradition. And this provision basically says that a judge could deny the remedy of a specific performance if under his own law, for the type of transaction and set of facts, he wouldn't be allowed to grant a specific performance. And what we have here, I saw that Professor Hugh is here, and there are other people from the common law tradition. And this is the case because a specific performance, and correct me if I am wrong, in the common law jurisdiction is a remedy that comes from the equity court. and it would only be granted when damages would not be able to grant justice to the party suffering the breach. And this may be the case only, for example, when the seller fails to deliver goods that are unique in nature. The clearest example is, let's think that the seller was obliged to deliver a Picasso painting of a specific name, right? And very well identifiable. So suddenly, the seller refuses to deliver the Picasso painting. In that case, the buyer would have a claim for a specific performance. I want your judge to order the seller to deliver that Picasso. That would be a claim of a specific performance that could be allowed straightforward in the common law because it's a unique good. If you deny that specific performance and you award in estate damages, the damages would not actually put the buyer in the situation he should be fairly placed, because the painting was so unique that what he wanted was the painting, not damages for the painting. Obviously, the case is different when the sale is about a commodity, something fungible, something that you can easily obtain in the market as a buyer. And so, in that case, a judge may deny under his own law a specific performance because damages would be able to make justice to the buyer. Okay? So that's the exception in Article 29, but only works for a specific performance that consists in the delivery of substitute goods. It doesn't work for the specific performance that consists on the repair of the goods. Now I have a case here. This is just if you want to take notes, but this is it's an old case. Seller from Italy, buyer from Germany, where you have a clear example that in some situations, when the goods are defective, the buyer may request the delivery of substitute goods. Okay, we don't need to speak more about it. You may take the name, or I share the slides later on if you have to. You want to have some examples. Good. Sorry. Questions on this? On a specific performance? No? Oh, I think I didn't speak about repair, right?
Okay, while we're going through the slides, if I may just fill in the time in between on specific performance. In Serbia, like in many civil law countries, we deem that there's some hierarchy of remedies available to the parties, and specific performance or seeking performance from the other party which has not performed is number one. Whereas in the United States or in other common law countries, as you heard from Edgardo, specific performance is rarely available in very specific cases, whereas damages are the remedies of the first resort. And there's like a philosophical difference in understanding what contract actually means. For us, having the legal tradition based on Roman law, we promised to the God, before the God, that we will, perform the contract. So pacta sunt servanda is such a big Latin saying. Whereas in the US, not to say that they are not expected to perform the contract, but there's no moral element to it, how you're going to be a bad person if you don't perform. Sometimes it's economically more beneficial for you to breach the contract than perform, and that's fine. Because the legal philosophy underpinning contract in US law, to the best of my understanding, is by promising to do something, there's an implied promise to compensate for damages the other party if she or he suffers damages. So for them, conceptually, damages are the normal remedy for breach of contract, whereas for us, it's a different thing, whereas in practice, it might be the same thing, right?
Yeah, I wanted to emphasize that in practice, and Edgardo mentioned it, there is no case law on Article 28. And we might ask ourselves, why is that never disputed? That is because parties are more sensible than the law in civil law countries. Imagine you're buying a TV set today, yeah, and the seller doesn't deliver. So would you go to the court and go through 3 instances until in 5 or 6 years you get a decision of your Supreme Court that you're entitled to specific performance for this TV set that at the time you get the decision will be totally outdated? No sensible person would ever do that. That means if you can turn to the market and get the same thing on the market, maybe for a higher price, you will do that. You will avoid the first contract, go to the market, buy the things there, and ask for damages for the difference between the contract price and the market price. So that is reality. So the common law approach is the reality, and the civil law approach with the specific performance as something like the backbone of the obligation is nonsense.
And plus, we're talking about business people here. I mean, we are saying, or Gottlieb has told us this morning, that the CISG does not differentiate between civil sales and commercial sales, or civil and commercial law. But in fact, this convention was designed to apply for international trade, not necessarily for our transactions with Ingeborg and I transacting, I don't know, jewelry, but for the business people. And for them, money is what matters. They don't care about this specific TV set, or they don't care about these specific shoes. They care about the profit they're going to make out of resale of those TVs or shoes, or about the profit they're going to make by using whatever fuel they're importing and that's needed for certain purposes. So money is all that matters, and it really makes sense. The damages should be the primary remedy.
Yes, and I think even in domestic contracts, that's a trend, that there is no request for a specific performance anymore. Yes. Okay, I thought I had a slide specifically on repair. I don't have it, but Article 46.3 talks about this possibility, this remedy for the buyer. The buyer, when he receives non-conforming goods, either because the goods are not under Article 35 because they have physical defects or non-physical defects, and something Ingeborg didn't have time to speak, but nowadays many goods also must need to have characteristics that are not physical, but that are related to the way they were produced in sustainable manner, for example. But when there is a claim for that, the buyer is entitled to request the seller to repair the goods. And he's always entitled unless repair is unreasonable. And therefore, this term unreasonable requires to be interpreted according to Article 7 that you already heard about. That means it has to be interpreted in accordance to its international character, the need to promote uniformity and the observance of good faith. And basically all the provisions we may talk about from now on can be or should be interpreted with the tools of interpretations that Ingeborg gave you this morning and at the beginning of this afternoon. There is a CISG advisory opinion on this. For those who want to get deeper, it's opinion number 2021 that talks about, I think it's 21, talks about and give us some guidelines on when repair is reasonable. Later on, I'm going to talk about Article 47 that provides a right for the seller to repair. Not a right for the buyer to ask for repair, but a right to the seller to intervene and repair. But until then, I'm going to speak briefly about avoidance of the contract. Avoidance of the contract, you already heard some about it, but I think it's good that I just do the recap so that you see specific examples that apply the concept of avoidance of fundamental breach in different scenarios. So, for example, the remedy is in Article 40. The remedy for the buyer is in Article 49.1a that allows the buyer to avoid the contract, we were told that avoid the contract means terminate, right? I know that this is an independent concept, but just so that we are just in the same page, means terminate the contract. And terminate the contract means that the obligations that were performed before the avoidance are given back to the respective party. And that's why it's called a remedy of ultima ratio. Professor Garro mentioned it, because there is lots of cost involved in giving back the performances that each party receive, and that's why the threshold of a breach is higher. So when there is fundamental breach, we can avoid the contract, but there is also another alternative. Under the CISG, and this is different to some legal systems, when the buyer suffers the breach, he's not obliged to give an additional period of time to the seller to perform. He's not obliged. Some systems require that because it is important that the seller is placed in what is called mora, in Spanish, delay. I don't know if you have your own concept on that, right? That is placed in delay so that there is certainty that there is breach. Under the CISG, you don't have that obligation. However, the buyer, in some scenarios, to be able to prove that the breach is fundamental, has the option to give an additional period of time to the seller, so that if the seller doesn't fulfill his obligation to deliver, within that reasonable time, the seller will be considered to be in fundamental breach. Okay? And that's the idea of Article 49.1b, and it comes from a German concept that I don't know how to even pronounce. It's called, I think, Nachfrist. Nachfrist. Yes. So it comes from the German law tradition, this possibility for a buyer to give an additional period of time so that if the seller doesn't comply with that, it will be found in breach. But the period of time should be reasonable again. And again, this is a concept that needs to be understood under the circumstances. What would be reasonable as a period of time for the matter at hand, right? What does the seller needs to do to perform delivery? That's important to know. But for now, I think it's enough for this introductory session that you know that this possibility exists, but the period of time should be reasonable. Okay? Now, we must know that non-delivery of the goods or non-delivery of time is not necessarily a fundamental breach. Okay? It depends on the circumstances as well. And for that, I want to talk about this. I'm not going to talk about these elements because Professor Garro already mentioned them, but I think we should go to some case scenario which are, sometimes when I present it to my students, look a bit harsh because they show that reaching the level of fundamental breach is not always easy. You have this case between a Dutch seller and a German buyer that agreed that the goods should have an origin. They should be of British origin, but instead the certificates, they were from South Africa. I think it was oil. Yeah, cobalt sulfate. Yeah. So, and the seller delivered the goods, but instead of having a British origin, the cobalt sulfate, it has a South African origin. Do you think that there is a breach here? You agreed with me that there is a breach? I mean, he sent goods which were of South African instead of British. Do you agree? There is a breach, right? It's clear. Any deviation from the contract, from Article 35.1, is a breach. The question is whether this is a fundamental breach or not. Whether the buyer has been deprived of what he was entitled to expect under the contract. Any views? No? Yes.
Was it in the contract? Was he expecting them to be British, or was it in the contract?
It was in the contract. They should be from British origin, and the seller delivered South African. And I'll tell you something. It was not a small breach in a way, because at that time, it's from the 90s, many countries would not allow the import of South African goods because they had imposed an embargo on South Africa relating to the fact that South Africa has these so-called apartheid policies. So many countries would not receive cobalt sulfate from South Africa. So the buyer wouldn't be able to resell that in many countries because the import of South African goods were not allowed. So, fundamental breach, no fundamental breach? Fundamental breach? No fundamental breach. No fundamental breach because the court, the seller was able to prove that this specific trader, it was a trader that sold in other parts, could have sold those goods in countries that did not impose an embargo. So that only fact was enough for the breach not to reach a fundamental nature for the court. Okay? Different case. I have a seller from Austria and a buyer from Germany. They agree on the sale of apple juice concentrate. And the seller, instead of delivering apple juice concentrate, you send something mixed with glucose syrup that couldn't be called apple juice concentrate. The contract provided that he should deliver apple juice concentrate, but he delivered apple juice with syrup glucose. And the buyer said, well, we all agree this is a breach of contract, Article 35(1). And the question is whether this is a fundamental breach. The buyer said, well, I wanted these goods to produce apple juice, but with the concentration of glucose syrup, I cannot sell apple juice anymore, or I cannot call my drink based on apple juice because it has too much sugar for it. I would need to call it drink with apple flavor or something like that, but I cannot call it apple juice. What do you think was the solution? Fundamental breach or not fundamental breach? No? Same, no fundamental breach. The court considered that if the buyer was able to use the goods in the normal course of business, even to produce something different or sell it at a reduced price, there was no fundamental breach. Okay, so you see that the standard Professor Edgardo talked about this morning is quite high. A different case decided by the Supreme Court of Switzerland. Okay, I don't give you the decision. But this is about meat. So the German seller sold to the Swiss buyer meat for the Egyptian market. And the buyer from Switzerland complained that there was too much fat in the meat. It was not of the quality required under the contract. And he wanted to avoid the contract, to terminate the contract. Do you think that he was able? No, No, because we already know it's very difficult, right? Yeah. It says, well, you can claim damages instead. Oh, obviously, all these cases do not allow for avoidance of the contract because there is no fundamental breach. But in all those cases, you have a claim of damages as a buyer. And this is basically what they say. If you are able to use the goods or resell them in the ordinary course of business without excessive burden for the buyer, there is no fundamental breach. So you may take the fat, the extra fat, and you charge that cost to the seller as damages, right? And it makes completely sense. Why do you want to take back the complete goods to Germany if you can, in a way, do the job there and request damages compensation? Last case from Italy, from the country of Professor Ferrante. Pay attention to this one. So the buyer is in Italy and the seller is in Hong Kong. And the buyer requested the delivery of knighted goods. I don't know, the word it's even weird to me, but knighted goods is like, clothing that is like made by grandmothers. No, this is but you know what I mean, right? My grandmother did it, but I don't know if all grandmothers did. They agree that the delivery should be on the 3rd of December of 1990. And they agree on the payment terms. Well, before the date of delivery, the buyer issued a bank check, the Italian buyer, but the goods were not delivered. He paid, but the goods were not delivered. And after the delivery date, the Hong Kongese seller wanted more to increase the price, so the buyer refused. The buyer from Italy sued the seller from Hong Kong and requested to terminate the contract so that he can have his money back. The goods were never delivered, but in any case, he wanted his money back because he paid and they were not delivered on the 3rd of December. Do you think he's entitled to avoidance? Do you think there was a fundamental breach?
Yes.
Yes?
Yes.
Wouldn't it be nice to allow the seller in Hong Kong to deliver later? Because I just told you that late delivery per se doesn't constitute a fundamental breach. But
if they were needed for the 3rd of December, then it's fundamental, and if not, then they have like extra period, right?
yes. No, yes, I mean, I think you are in the good track, because what is important here, I mean, late delivery will constitute fundamental breach when time is of the essence. When delivery on time is of the essence. But for this to happen, the contract must state expressly or impliedly that time is of the essence. And in this case, it is stated so impliedly. Do anyone wants to wonder why? Look at the dates and look at the type of goods. What do you think? What type of goods were those? Yes, Christmas. Christmas. It was more for decoration than for people. It was Christmas goods. And so it was important impliedly that the goods arrive in Italy, or at least delivered wherever they needed to be delivered before the Christmas season started. And because of that, the court considered that there was a fundamental breach, even if delay per se does not amount to a fundamental breach. So whenever you can whenever a contract states that time is of the essence, either expressly or impliedly, it is more likely that late delivery will constitute a fundamental breach. Questions on that? No? No questions? Okay. Well, Article 48 allows the seller to cure any defect on the goods. This, more than a remedy for the buyer, is a right of the seller. The CISG gives the seller this right to himself or through a third person to remedy or to cure, in other way, any non-conformity of the goods. And the provision in particular tells us that this can take place after delivery and subject to Article 49. That means that the right to cure the defect is only possible when there is no fundamental breach. But in a way, if he is able to cure the defect, that also means that there cannot be fundamental breach. That there is a breach, but not fundamental. If you want to explore more about this, the CISG Advisory Council rendered in the same opinion on Article 46, is opinion number 21, some guidelines on Article 48. But the main rule here is that the buyer must accept the seller's right to cure when it is reasonable under the circumstances. And again, the term reasonable should be interpreted in this case according to good faith, and also on the basis of the specific facts of the case. And so, as you have two conflicting interests here, the right questions to ask are those. At what point in time does conformity amount to a fundamental breach? And how does the seller's right to cure prevent the buyer from avoiding the contract? And the prevailing view basically is if the defect can be cured without unreasonable burden for the buyer, there will not be fundamental breach. And so the seller should be entitled to proceed and cure the defects on the goods. Question? I'm not sure how I'm doing on time. How much time do I have? Yeah?
Very tight.
Okay, well, if that's it. No, I think I can pass it. I was going to talk about damages, but since our next speaker is already here.
Yeah, our next speaker is already here. And thank you so much for your presentation. I mean, I have no reason to whether you can cover damages in like 5 to 7 minutes. But I've written 450 pages in my doctoral thesis. That's in the library, so no worries.
Time flies. Time flies. I thought I had more time, but I'm sorry for that.
Thank you for all these examples from practice, which adds to our analysis. And Mike will note down that we need another guest lecture. Asking for the money and the finances. And the professors you've heard speak to you today, they want you to take you back home, or I don't know. I mean, if it doesn't work that you come here as a guest lecturer, can they all go to Mexico and have class there, or in Basel, or wherever you are from?
Doors are open. The weather is fine over here. No problem.
Okay, well, as I told you before, Professor Schroeder couldn't make it. I mean, he will make it after midnight, so maybe we can meet later on in a pub. But Benjamin Gottlieb arrives from Zurich. Unlike our previous speakers, he is a practitioner, but he also has a keen interest in the CISG, and to my surprise, or many surprises, like on your profile, CV, you mentioned the particular interest in CISG, which is very rare when it comes to practitioners. Maybe Cesar is among those as well. But you would rarely see that on the websites of people who are actively taking part in dispute resolution, that they brag about the CISG. And he does not brag for accident. I mean, there's so much that he has done in the past that speaks in favor of him being an expert on the CISG. Among other things, which some of you may already know, he's the director of the Wismut School, Switzerland. So he organizes a crash course on the CISG and arbitration, usually the first week of October every year. And it can be attended remotely as well. You can always go to Zurich if you want next year. But if not, you can attend online, and some of you have done that in the past, I know for sure. And yeah, I can talk on and on about Benji, but let's give you the chance to say a few words to you. Thank you for being here.
Excellent. And I've never thought about the fact that I brag about the CISG on my personal page. It's less it's some dedication to the CISG. It's mostly the hope of a business case and attract business for those who have CISG cases around the world. Now, I'm joking, of course. As many of you, hopefully, and many around the world, I was introduced to the CISG through the moot court and sort of stuck with it until today. And I must say, surprisingly, you will hear over and over again, I'm sure, that parties tend to exclude the CISG, etc. But that's not the reality. I see we have many cases at our firm that involve the CISG. So we actually practice the CISG at our firm, sometimes because it was chosen expressly, sometimes because the parties forgot to exclude it, and sometimes because they tried to exclude it but were not successful. Poor drafting gives us some case law at the firm. Good. I'm perfectly aware that I'm the last speaker of today. You started, I think, at 10 and had an intense day of CISG. I envy you for the content, but not for the stress on your brains that you must have gone through. So let's fight through this last session. And with that, I also thank wholeheartedly to Milena for organizing this day and also having me at this late hour. Milena has asked me to speak about CISG and advocacy, and this morning, jokingly, I wrote her a WhatsApp saying, what the hell is CISG and advocacy? How can I combine these two topics in one session and cover it in 45 minutes? So in order to wake you up just a little bit, you had now a full day of CISG, so you must know why advocacy is particularly important when we talk about the CISG. And always when I ask a full room of students, I have this horror moments that I had in Turin when I gave a guest lecture in Turin, and I was so enthusiastic about the topic. I prepared and I threw the first question in a full room of students, and then I looked at my colleague, the professor from Turin, and he just shook his head and said, no interactive class here. But I'm sure you're different. So why do you think, after having heard today, advocacy could be interesting, in particular when we talk about the CISG? Yes.
Well, the thing about CISG that this crash course today highlighted is that there are many open questions of the CISG, of interpretation of the convention, of interpretation of the contract, and all of the issues that are open to different interpretations are naturally a field where advocacy is going to thrive, because you're going to be able to persuade the arbitrator or the judge that your stance on the CISG is correct and not the other person.
Good point. I'm just collecting a few points and then I'll give you my thoughts, some other ideas. Why is it different from your local law, from the law here in Serbia? I mean, of course, you need advocacy here as well, but what could be a difference when we talk about local laws and the CISG? Yes, please.
I guess because the CISG has a transnational element, therefore, as a local lawyer, you can expand your market by having clients from different countries and so on. So therefore, you cover this.
Very good argument. So I have one client that I worked for 3 years, and they rolled out a campaign of contracts. So 120 different contracts with 120 different counterparties, all sales contracts that had a duration of long-term contracts for 5 years. The market changed after 2.5 years. So out of these 120 contracts, 60 became problematic because of price level differences. And out of those 60, 30 became contentious. So 30 arbitrations in 30 different jurisdictions. So they had to hire lawyers around the world. They had to hire global counsel coordinating all these different arbitrations, etc. And we were involved in quite a few of those because most of the arbitrations were seated in Switzerland. And at some point, the legal counsel has become a friend over the years, and I told her, if you had chosen the CISG, we could have run all the arbitrations for you. And she was completely flabbergasted by this concept. But yes, you are right. I mean, CISG gives you a reach beyond your local jurisdiction, which doesn't answer the advocacy point, but to some extent it does, because it's an international law. So the fine points of advocacy become that more important compared to your local jurisdiction, where the judge and the opposing counsel and you all trained in the same system, and your Supreme Court's case law, etc. So you all speak the same language, literally and figuratively, and that's not the case with the CISG. So a Serbian lawyer being in an arbitration against a Swiss lawyer in front of an American judge cannot speak his or her local language. And I'm not talking about Serbian, I speak about the legal cultural language, right? So advocacy becomes a point, and yes, you can make more money as a lawyer, also never to be underestimated. One more point that I noted for me is the CISG is still a relatively young law. It's not, the Swiss Code of Obligation is now more than 100 years old. The CISG is not. So it's still developing. It's a simple law. It's an easy law. You've heard that today. And still you have a lot of different opinions. You have professors here in the room that on key issues do not share the same opinion, have not the same view. That has partially to do with own convictions. It has also to do with legal background. So the fact that this law is still developing and is not around for 200 years gives a lot of room for advocacy. You can go out, open different commentaries from professors with a Germanic background, a Swiss background, a continental Europe background, and then you can read commentaries from more common law authors, and you will find different approaches to the exact same legal provision and the exact same problem, discussing the same cases, some of those that were cited by Edgardo and the professors earlier today. And all of that requires lawyers that apply advocacy. I should have started with that. I might be the last one speaking to you, but in some respects, the most important session, not because of me, but because of all the information that you received today, would be an academic exercise if it's not applied at some point to real life cases in your local courts or in arbitrations seated in around the world. So yes, the academic side of it is extremely important. We need to know what the law says, and we need to be interpreted and explained and understood. But at some point, the lawyer needs to pick up all the hard work done by academia and translate it to a judge or to an arbitrator that is usually far less familiar with the CISG than they are with their domestic law. Now, a further point that we've heard before from the colleague here in front is the CISG itself has built in some necessity for advocacy. Just to throw a few examples, all of which I'm sure you've heard today. Article 3 says the speaks about substantial part and preponderant part of the transactions that determines whether a transaction is a sales contract or, for example, a contract for work that would fall outside of the CISG. What does substantial mean? What does preponderant mean? You will find commentaries on that. Sometimes they agree, sometimes they don't. Sometimes they give you a percentage. Sometimes it's more a feel to it whether something is substantial or preponderant. So already at Article 3, we start to need to require a lawyer to explain to a judge or to an arbitrator what that actually means. And sometimes we need to say, well, it's true that most of the commentaries say X, Y, Z, but they're all wrong because if we apply it to this specific case, the reality is completely different. Article 6, the exclusion of the CISG. So we have that in a lot of cases. I'm currently involved in one case where we did an extensive analysis at the outset because we are the respondent and the claimant started to argue under Swiss law. The CISG is clearly applicable. Opposing counsel actually wrote the commentary in the commentary that I'm editing on the exclusion of the CISG, and his view is completely contrary to what they pleaded in the case. So we did an analysis: what's better for us and what's worse, Swiss law or CISG. We were a bit biased because they started under Swiss law, so we thought they must have seen something in the CISG that is bad for them. We were looking for that. We found it. And we had a whole, debate on whether the CISG is applicable or not and what the parties actually meant when they chose Swiss law. I'm sure you heard that. It's sufficient to choose Swiss law or German law for the CISG to be included. So what did the parties actually mean when they said that? There was a previous contract where the CISG was excluded. They said, that's a clear sign. The parties didn't want the CISG. That's why in the first contract they excluded it. We, of course, argued, no. It's a clear sign that they wanted the CISG because why would they exclude it in the first contract and not in the second? I would love to say that we won, but we're still waiting for the award. We will win, I'm sure. Edgardo just spoke about the uniform application of the CISG, Article 7, when you need to assess what's reasonable. Reasonability is such an important point. I'm very sure that Professor Schwenzer talked about this to you, and she's right on that. You have this guiding principle of reasonability in the CISG and resolves a lot of issues. For example, standard of proof. I believe we won an important chunk of a case because of the reasonability requirement. We submitted spreadsheets in a case which before a Swiss judge would never fly. A Swiss judge requires almost certainty when it comes to evidence and to proof. Almost certainty is extremely difficult. If you just need to prove it to a reasonable degree of certainty, you can also submit spreadsheets and say, is it reasonable that worker XYZ falsified the spreadsheet back in 2011, not knowing that the case will come a couple of years later? But again, you need to explain that, and you need a lawyer to explain that to an arbitrator, because they will not naturally be so familiar with the CISG. And so on and so forth. We could speak about Article 8 and 9. Who is the reasonable person, the reasonable third person, businessman in the same shoes? I once taught a class in Code of Obligation at the University of Zurich, and a person obviously did the course twice, I don't know for which reason, and asked me during the session whether the reasonable third person is the same as last year. I then answered that person retired, but also the new guy is very nice. So we need to interpret who the reasonable third person is. You need a lawyer for that. And finally, a point that we quickly touched upon: why is advocacy so important when we talk about the CISG? It's because of the global application. You can find on the University of Basel's website, started by Professor Schwenzer, now continued by Ulrich Schröter, case law from all over the world, all jurisdictions, all courts, first instance courts, second, Supreme Courts. You can find it in different languages, etc., etc. That's unique to the CISG, or almost unique to the CISG, right? You don't have this global access to case law, not even in your own jurisdiction usually, this systematic collection of case law. You have a vast amount of commentaries, case notes, articles, etc., etc. And we need lawyers and advocates to look through those cases, to distill those cases, and to explain it to whoever needs to take a decision. And you need to put a flavor to it, right? Is a first instance court of a small city in Switzerland, does that have the same weight as the Supreme Court of Austria? Probably not, but if it suits your case, it suddenly does. It's the best court in the world, and it made a very compelling argument in the decision. So you have a lot of more room to play with that than you have in your local jurisdiction. If you have a first instance court in Serbia versus the Supreme Court in Serbia, no one would listen to the first instance court. You always go with the Supreme Court. That's different with the CISG. You have a vast amount of sources. So to conclude my part one of my three-part intervention tonight, why is the advocacy so important when we talk about the CISG? It's because of the particular nature of the CISG. More important, I would argue, than it is in your local jurisdiction. That brings me to part two. And we move now slightly away from the CISG, and I will talk more about my experience as an attorney. I will try to make some references to litigation, to court litigation, but of course I'm not familiar with your system or not intimate with your system, so I will focus more on arbitration, which is what I do on a daily basis. And if you have questions, if something is new to you or unclear, just raise your hand. Now, part two, how to be effective in advocacy. And the main point is preparation. You cannot overstate how important preparation is. That's true for both written advocacy and oral advocacy. It's especially true for young lawyers. You have an edge and an advantage over everyone who has more experience than you. You will never be able to compete on experience because you just can't. It will come over time, and that will be very helpful. Experience is a helpful tool. But you have more drive, sometimes more time, and more energy than everyone who came before you. So what you can do is be more prepared than everyone else in the room, and that should be your goal always at all times. And it's easy. Just sleep 2 hours less and read the documents, read it again before you send it out to a partner, to the client, to whomever. Be always more prepared, more diligent, and more in the details than anyone else. My very first experience in Switzerland, you have to go through a 1-year traineeship before you can sit for the bar exam. I was a trainee lawyer, and we had a huge arbitration. It was one of the biggest the firm ever had, and I was lucky to be the intern on that case. And we had this huge long spreadsheet with hundreds and hundreds of documents, and I just spent day and night going through those documents. And at some point after 4 or 5 months, I was indispensable at every meeting because no one else knew the documents and knew where to find what, and it was just quicker to have me at the meetings. So I was able to attend the meetings with the clients. And that taught me the lesson, be always the best prepared in the room. That also translates down to your actual case. If you have a case and you need to argue it, you need to prepare diligently. Usually when a new case arrives and we know we do the advocacy on it, the very first thing you do is to develop a case strategy, a case theory, if you so wish. That entails both a factual side and a legal side. The factual side you can't manipulate too much. To be quite frank with you, you can to some extent. You emphasize the better facts, and you are a bit more quicker on the less good facts. But that's only once you start advocating the case. When you sit down with the client, you want the full Monty. You want that they, so to speak, get naked in front of you and tell you the whole story and give you all the good facts and all the bad facts. And then it's for the lawyers to decide how we use those facts in a case. The legal theory is more tricky. Here it's, why it's worth that you studied here and that you pay attention in class, because here you can start to play. Are we going for specific performance? We've heard almost never, because you're more interested in the money. That's true. In some circumstances, it can be a mean tool. You know that the other side has difficulty to perform. So you go for specific performance, you put pressure on them, and then you hope you find a good settlement. So you don't have to go through the whole process. So that's what I mean by legal theory, right? What's my burden of proof and what's my standard of proof? Can I meet that? And if not, how else do I structure my case so that I can still get my money? Here, my tip to you as younger lawyers is find a deal with your mentor. I'm sure if you sit in any career or future lawyer sessions, everyone will tell you it's important to have a mentor, and I agree. Find a deal with your mentor that you can bring every idea that crosses your mind. The mentor can then say, no, that's, what's a polite word for bullshit? That's, it's not going to fly. And then you have to stop. You can't insist, right? You have to go out of the office again. But you're allowed to bring every idea. That's the deal I had with my mentor. And, 80% of the time I left the office, but 20% of the time I had an idea that no one else had. So that's nice, and it gives you some drive when you talk about, or when you think about the legal theory. Then, when you prepare for the case, you need to put yourself into the shoes of the tribunal or the judge. And the best way to do that is to prepare a decision tree. You say, what's the question before me, and what are the decisions I need to take to get to a solution? That's a very pragmatic approach, and it works with, I would say, with most judges and arbitrators. It certainly works with civil law judges and arbitrators, because they need less of the storytelling, etc. It's important, I'll get to that. But at the end of the day, a civil law judge will always, look at what do they ask me to decide, what's the legal basis, what are the prerequisites for that legal basis, and are they met or not? And that's, I think, a good approach for everyone in this room. The same lecture in New York would maybe look a bit different, but I think for today's purposes, a decision tree where you look at what do I want, what's the legal basis for it, what are the requirements for that legal basis, and are they met or not, will give you a very good outline and roadmap to your legal brief. Another tip that I can give you is to build a relationship with your client. That's, from case to case different. If you have a lot of lawyers on the case, maybe you as a junior lawyer will not be the person to go and have drinks with the client. But sometimes that's actually true. It happens, again, I'm telling my war stories, but anyway, you have to listen, so that's a good audience. We had, this is public, so I can talk about, we were involved in a very large arbitration that concerned the second channel of the Panama Channel that was built. The old one, which is very old, is narrow, and ships have become larger, so they can't pass through. They had to build a second channel in Panama, and that sparked, I think, currently 6 arbitrations that were very contentious. And I was again a junior lawyer. The hearing was in Miami, and there were on each side approximately 100 to 150 lawyers involved. A huge room with hundreds of seats. My role was super limited. I obviously didn't have a speaking role. I was there to assist the partner on the case. But at the end of the day, with all these lawyers, the client wanted someone to talk in the evening, and I was there, and I could take on this role and sort of support the client and be there and have an open ear. Another way to do that is usually it's simpler and cheaper, and if you're involved, to travel to the client and meet the client at their facilities. That's something I highly, highly recommend. One of the worst things of the pandemic for me is this stupid Zoom and Teams, because now we think we can do the same just sitting from our offices. We cannot. We have to travel to the client. We have to see the facility to see what they are producing and how it looks like, how big it is, what are the difficulties, to see their offices and to build the relationship with them. That will give you an advantage on advocacy, because that's how you can start to identify with your client. They will trust you. One issue you will encounter is if you identify witnesses, people that were involved in a project, usually are afraid that something is going to come out that they did wrong, a mistake they did. And of course, you're not going to use something and you're not going to hurt their career or anything, but they need to trust you first. And that trust can hardly be built over Teams. At least that's my experience. So this concludes the second part of the three-part presentation, which is how to be effective as an advocate. And the conclusion or the summary of that is, be prepared. Be better prepared than everyone else. Go the extra mile and build interpersonal relationships with your clients and with co-counsel, if you have co-counsel, and with your team at the firm. And coming to the last one, part 3, is the art of advocacy. So now we go down to business. What does it actually mean? And I've divided again in 3 parts. One is written advocacy. Written advocacy is often underestimated. Usually, the legal briefs, the written legal briefs, are just used to put in all the arguments. We want to make sure that somewhere in the brief the argument is mentioned. The letter that we think is key is somewhere mentioned, etc. And we forget that it's actually something that a tribunal or a judge will have to read at the end of the day. So that should be your guiding principle. Someone has to read that and understand it. And it needs to be at least a little bit interesting. So don't focus too much on oral advocacy. It's also important. But the written advocacy is even more important. Of course, your local courts will have rules on what you can do and cannot do. I'm not going to comment on that, but you have to stick to that. Don't reinvent the wheel. But in arbitration, the situation is a bit different. First of all, everything is in English. Yeah, usually, of course, there are arbitrations in other languages, but majority is in English. Most of us are not native English speakers. And so are, the tribunal usually are also not English speakers. That doesn't mean that you don't have to care about your English. You should try to improve it. There are good books on legal advocacy and legal writing in English. Again, my mentor at some point gave me the book in a passive-aggressive mood and said, maybe you should read that. He's a native speaker, which was helpful for for my self-consciousness. And it never stops. So I think it was 2 months ago, I sent a draft to him. Now it's my partner, he's no longer my boss, but the message has not arrived to him yet, it seems. And he sent me back a bubble comment to one of the paragraphs where he copied in a PDF file to an article that is called The 10 Commandments of Written Advocacy. And then he put just read point 3 and point 5. So it never stops, but it's also good. You should try to improve, and there are some very important rules that for us non-native speakers are just hard to remember. It doesn't come natural, right? So we need to train, and we need to have someone that tells us when we go wrong. Some very short ground rules. Try to have very short sentences. I'm not sure how it is in the Serbian language, but an intelligent German sentence is deemed to, it's deemed to be intelligent if it's half a page long. We all know that's not true, but at least that's some people have the impression. It doesn't work in German, one, and it certainly doesn't work in English, and not at all in a legal brief. So make short sentences. Just say what you want to say in a short sentence. If you have an and, or if you have a semicolon and then it goes on, just make a full stop and start a new sentence. It works. Drop all, a tip that I got is drop all the however and it, in light of the above and unfortunately, comma, all these introductory words, just drop them and see if the sentence still works. In 80% of the cases, it still works. I'm just throwing out numbers. I have no idea in how many percentage of the case it works, but in a lot of cases. And it makes the read much easier for native speakers and non-native speakers. Keep it simple and international. We lawyers, and especially don't know if it's especially, but also the CISG aficionados have a tendency to use Latin expressions and to say Nachfrist instead of additional period of time. Just use plain English. Don't use Latin expressions. Don't use expressions in other languages. It might sound intelligent, but you might have someone on the receiving end, the tribunal, that doesn't know the expression. I had to study Latin before I could study law. That was the case in Zurich, but it's certainly not the case in the rest of the world. Just stick to English. You don't want to seem smart. You want to win the case for your client. Those are two entirely different goals. Another tip that I can give you is make your point up front. It's the worst for a tribunal, and I have sat as a tribunal member, not in 100 cases, but in a few, to find out sort of at the end of either a paragraph or worse, at the end of a chapter, what someone wants from you. Put it at the front, at the beginning of a sentence, at the beginning of a paragraph and a chapter. Say what you want and then develop your theory. That's much easier to follow than trying to guess what the heck someone wants and then to find out at the end. And then you have to go back up to see what the arguments were. Use parties' names. That's also, we're all very excited when we first learn to correctly use respondent and claimant and defendant and plaintiff. Just use the parties' names. There is no rule that says we have to use respondent and claimant. For a busy arbitrator in particular, but also a judge, they can't remember which party is the claimant and which is the respondent. Just use the parties' names. Don't overuse abbreviations for the same reasons. If you have 5 contracts and you have 5 abbreviations, as a judge, you always have to go back and see which, what is the abbreviation for that? It will add a couple of pages, yes, but it's easier to read. Make it always easy for the reader, for the judge. And then a more global point. Be relatable, be credible, and be sincere. Don't exaggerate. That's what you see in, I would say, all my first and second drafts have hyperbolic language, exaggerated examples, analogies that sound cute but don't really work. Either you can eliminate those yourself, or you need a partner, a colleague that eliminates you all this language. Only use one adjective, not 3. Lawyers always say this breach of contract was egregious, unheard of, and unprecedented in history. Just use one. Okay? And I can tell you, before I acted as an arbitrator, I did a lot of cases as secretary. And I read all these submissions from the parties, and I just didn't care about all these allegations and all these language that try to insult the other side and exaggerate, and how these are 2 business parties, and you read just through the important element, that you need to apply the legal provision, and all the rest is just not interesting, and you lose credibility. So be very professional, minimize exaggerations and strong language, etc. it will make you a better lawyer. And in the same context, respect your opponents, both the party and the other lawyers. It will make you a better lawyer, and it's just healthy for the entire legal system. You're defending your client's case. They have the exact opposite view that you have. Deal with it. Okay? That's how an adversarial system works. It's not personal. The last point for written advocacy that I want to mention is be creative, especially when you deal with arbitration cases. Yes, usually we just send a legal brief, but sometimes, again, you have to put yourself into the tribunal's shoes. What's easier to understand? In one case that we had, it was a extremely complex chemical/technical issue. Now we described that over, I don't remember, 15, 20 pages. I certainly didn't understand it, even though I wrote it. But then we asked someone a specialized company to make a video out of it. And we put the video on file as an exhibit. And the video was very easy to understand. That wouldn't fly in local court in Zurich, but it's possible in arbitration. So try to think outside of the box, and especially you, try to use the new technologies. Artificial intelligence is on the rise, we all know about that. Try to use it. Try to, probably when you will be lawyers in law firms in 2, 3, 4 years, you can tell, create an image of XYZ, so that at least you have a similar image, and you can tell the tribunal, look, this is more or less how it would have looked like if the construction would have been finished in time or something like this. Just try to be creative. Don't do everything as the ones before you. That's how you're going to separate yourself from them. I have 4 more minutes, and that leaves me just enough time to have a few words on oral advocacy and some general points. Oral advocacy is, in state court litigation, sometimes not relevant. I don't know how it's in Serbia, but in Switzerland, you will never have almost never an oral argument before a judge. And if you have it, you write it down and then you read from it. I had to endure that twice in my life. It's very painful. And if you're not reading exactly word for word, the court secretary will be very upset because they get the notes before. So luckily, that's not the case in arbitration. You have opening statements, and you should really use them as opening statements. That's where you can shine as an oral advocate. You can persuade, you can have eye contact with the tribunal, you can have PowerPoint slides where you highlight the most important documents and put those documents under the nose of the tribunal. Again, this requires preparation. I talk too much about him, and I don't know why. But again, my partner, Chris Bogue, he won the ASA, the Swiss Arbitration Association Advocacy Prize, and I must painfully admit he is in fact very good in oral advocacy, and he prepares for each and every hearing, opening statement. He writes down word for word what he's going to say, and he says, pause here, and marks it in yellow. And he says, click PowerPoint slide when he wants someone to click, and drink water. And it's all written down. And he repeats and he trains and he prepares on that script as long as he can, for so long as he feels comfortable to speak freely. And it will be almost word for word what is written down. He uses that also to train for time, because nothing is more annoying, I have 1 more minute, than to be over time. So we are always exactly in time, and I'm trying to do the same, and I can really recommend you do the same. You are not as good as you think you are. You are only good if you really put it on paper and you train and you prepare. That will give you the edge over the other attorney on the other side, because they never do it, and it shows. Final tip. I leave out some of the tips, and I address my last tip to this specific room, because usually when you go to law firms, you will not be the one to conduct all the cross-examinations and interrogate the expert and have the opening statement and the grand closing. Usually you sit 2-3 chairs next to the partner, and she will do the opening statement and she will do the cross-examination, and you assist. Don't underestimate your role. It's a very crucial role, and you can shine. You can have, under control all the logistics of the hearing. You can prepare the PowerPoint. You can be the one to exactly walk through the PowerPoint and have whatever the first chair needs handy and ready before the first chair even thinks about needing it. Again, that requires preparation, but that's a crucial job, because it's quite nerve-wracking to be the first chair and, for example, do cross-examination. And to know that a team member has everything under control and you can focus on cross-examination is a very important part of that process. So don't be sad if you're not having the key role in a hearing for the first couple of years. Quite the opposite. Observe and shine through your preparation and help to the first chair. And then at some point, you will receive a phone call at 11 in the evening before the first hearing day, and the partner will tell you, I didn't quite prepare for the first cross-examination tomorrow morning. Do you think you can handle that? And that will be your first sleepless night before a hearing, but it will also be a great moment. And with that, 1 minute late, I'm sorry for that. I hope I could give you some insight into advocacy, especially when it comes to CISG. And if you have questions, I'm around. Thank you so much.
Any questions left? He did say he's around, and I promise you he is. No? Not in public? Okay, then I invite my dear colleague, Mr. Gottlieb, to say a few words at the end, as he often spoke at the beginning of today's event.
It will only be a few words, I can assure you that. And I would really like to thank everyone for coming here, or the members of the Advisory Council, or the collaborators and the dear faces I don't see so often. I see them at least once a year in Vienna, but it's always good to see them a bit more often, and in Belgrade in particular. And I'm sure you have enjoyed this, because this was a special day here at the Faculty of Law. Rarely do we have the chance to have the CISG, I would say, both compressed and unpacked in a single day, what I could surely call a crash course, but I'm sure that even if you take bits, and I cannot hope for more than that, bits of what you have learned or heard today, in your practice, I think that you will do great. On a funny note, in my first case under the Swiss rules, Benjamin was the secretary, and it was a CISG case. It was a fairly big case for our standards, not for Switzerland. So you will find CISG often in your practice. I wanted to say that, I said that to Professor Schanzer today. I think some of my students told me they attended an online course, and whoever spoke said that he or she has not encountered CISG after encountering it at the MOOT. And I thought it could be in Switzerland if they opt for Swiss law and exclude CISG, but for Serbia, and I would say for Balkans or for Eastern Europe, CISG is the norm. So better get used to it and better get familiar with the way in which you can navigate. And on that, I would like to thank everyone and thank you for your patience, and the final round of applause for our speakers today.
And that's all, folks. Have some cake. Następstwo z Was. last exercise.